Good afternoon, everybody. My name is Christina, and I'm with Atlantic Institute. And we have with us Miss Catherine Fleming Bruce, and she is our Independent Dialogue Coordinator, also with Atlantic Institute, bringing to us a very timely conversation dealing mainly with the state of South Carolina. And I'm going to go ahead and turn it over to her so that she can lead us tonight in this conversation that we have.
Well, thank you. Thank you so much, Christina. Hello, everyone. Thanks so much for joining us. My name is Catherine Fleming Bruce. I am with T-NOVSA Global Commons here in Columbia, and we have a very exciting program and a very historic event that's coming up that we think is very much connected to dialogue and voices in South Carolina and nationally. So we're going to be talking about the Alexander versus South Carolina NAACP redistricting case. And we will be joined in that conversation with three guests. Our first guest is here on the screen with us. Charles Mann, you want to go ahead and pitch your bona fides to everybody?
Oh, okay. Thank you very much. My name is Charles Mann. I'm in the upstate of South Carolina in Spartanburg. And for the year of 2021 and 22, I was one of three redistricting advocates across the state of South Carolina. And what we were doing at that time was to educate citizens on what really redistricting was, because it's one of those animals that we only engage in every 10 years, and our 10-year memory kind of lapses. So we kind of bring people up to speed. And we also were advocates for fair maps across the state of South Carolina, which is what this case is about. And we made testimony before the state legislative bodies to advocate for fair maps. And it appears, in my estimation, that the legislature had another agenda. I went back and looked at some of the things that were talked about. Most of the people that appeared before the legislative committees, all were advocates for fair maps, okay? Particularly in District 1 and District 6. And you'll hear some of the other legal guys coming on later that, and I say this to people all the time, do you realize that Congressional District 6, which is Jim Clyburn's district, runs from Columbia, South Carolina to Charleston? Mm-hmm. When I say that to people, they go, what do you mean? That's a hour and a half drive. Well, that's how the district goes. And that district was done that way based on racial gerrymandering. And we'll get into more of that as we proceed. Thank you, Catherine. And you want me to say more, and I'll just keep talking.
I know. We're going to introduce our other two guests who'll be speaking tonight. One is Mitchell Brown, and he is with Solve, and that's an organization that has been working with voting rights for a number of years. And we also have Antonio Ingram, who is with the NAACP Legal Defense Fund. So we're going to, I'm going to share my screen now, and we're going to have our first conversation about this significant, historically and culturally significant case with our first guest, Mitchell Brown. Okay, well, hello everyone. My name is Catherine Fleming Bruce. I'm with T-NOVSA Global Commons, and I am an independent.
Hold on, Catherine.
With the Atlantic Institute.
Hold on one second. I almost was wondering about that. You got to screen share that. So I see your screen with the two interviews, but then I think when you pulled up the video, that's another screen.
Okay.
So keep that video up. Exit screen share.
Exit screen share.
And then come back and screen share with that video up.
Okay.
I was almost wondering that, but I thought, no, that should work.
Now's it working?
Yep.
Okay.
There we go.
And their mission is to make sure that dialogue is a part of what we do, a part of our social justice work. and that it is effective and that we kind of demonstrate good examples of dialogue. So
Hmm.
in the show that we're doing today, we wanted to talk about Alexander versus South Carolina State Conference of NAACP. There's a case that is now before the Supreme Court. It's going to be heard on October 11th. And there are going to be a number of events happening around that day. But we wanted to take this time to make sure that people understood what is Alexander versus NAACP. Why is it important? And why should those of us in South Carolina and those of us across the nation be paying attention to this case and its outcomes? So I'm going to have several guests today, and my first guest is Mitchell Brown. I'd like him to talk a little bit about who he is and the organization that he's with and why that organization cares about Alexander versus South Carolina NAACP.
All right, well, thank you for having me, Catherine. My name is Mitchell Brown. I'm Senior Counsel and the Director of the SOLVE Network at the Southern Coalition for Social Justice. SOLVE stands for Southern Leadership for Voter Engagement. We were created as a coalition and network after the Shelby County Beholder case in 2013, where we decided that it was necessary to bring Southern leaders in throughout the South, broadly defined Southern leaders in the South, to work around voter education and voter engagement in the South, given that the federal government is no longer going to be essentially protecting the voting rights in the South before voting laws took effect. And so why this Alexander v. South Carolina first state conference of the NAACP case is very important to SOLVE and very important to SCNAACP is because it deals with racial gerrymandering. SOLVE's mission and SCSJ's mission is to fight, part of its mission is to fight for racial justice. And racial gerrymandering, for those who may not be familiar, is the moving around of voters of color into various districts during the redistricting process in order to dilute their voting power. There's two types of gerrymandering, racial gerrymandering that we look at: cracking and packing. Cracking being splitting up voters of color throughout the state or throughout a locality into various districts in order to dilute their vote. Or packing, which is putting a lot of voters of color into one particular district when they could be split up into multiple districts and have more voting power. Again, the goal is to dilute the voting power. And so with the Alexander case, what happened is the state of South Carolina legislature decided to move voters, Black voters from Congressional District 1, which is on the Eastern Seaboard and includes Charleston, and move them into Representative Clyburn's district in CD6. And when Representative Clyburn's district is a majority Black district as it stands, and so adding more Black voters to his district was one, packing them into that district, but also it was, diluting the voting power of those voters who may still, those Black voters and voters of color who may still be in CD1. And the legislature said that they did this for political reasons, to make that district more Republican than Democrat. And they, in order to achieve that goal, they had to move these Black voters from CD1 into CD6. That matters to SOLVE and SSJ because the movement of Black voters into a district for partisan reasons should never be tolerated. And the dilution of the Black vote in South Carolina and the influence that these voters may have had in CD1 that they now don't have because thousands of Black voters are moved in CD6. That's an issue that we care about because it dilutes the voting power of those in CD1, those voters of color in CD1 as well. And so we have to fight back against it, and we have to hold the court accountable for upholding its jurisprudence around racial gerrymandering, which states that if race is the predominant factor in drawing a district, then the district is unconstitutional.
And I'll have to make a couple points. One is that it's really fascinating that SOLVE, and your organization were created after Shelby versus Holder.
Mm-hmm.
I think that's noteworthy because, there was a lot of gnashing of teeth and wringing of hands.
Exactly right.
After that decision was made, but there are some people who got together and said, we're going to do something about that.
Exactly right. like we had to come together as a network and as a coalition, because we had to save ourselves, essentially. And in doing so, we've created a robust network of over 250 organizations that all are geared towards helping protect the right to vote in southern states and helping to make sure that the states, localities, states and localities are held accountable for protecting the voting rights, particularly voters of color in the South. And so it's very, very important.
Right, and those states were formerly protected by
Correct.
Shelby versus Holder,
Correct.
that y'all are targeting, and now they're not. But I understand that Shelby versus Holder only took away one part of the protection. So
Correct.
what can you tell us what that part was?
Yeah, so Shelby County v. Holder was a case in 2013 that found that the formula, so for the pre-clearance formula, was unconstitutional. So let me explain what I mean by pre-clearance. It is starting in 1965 when the Voting Rights Act was first passed. In Section 5 of the Voting Rights Act, there was a pre-clearance provision which stated that certain states and localities, because you'll hear me use the word locales and localities, because the state itself, some southern states themselves weren't covered, but the cities and counties, certain cities and counties within those states were covered. And so it's states and localities as well. And so Section 5, which is pre-clearance, said that these covered states and localities that were determined based upon this formula that the court found unconstitutional, before they could pass any laws that affected voting rights in those states or localities, they had to get permission, essentially, from the Department of Justice, the United States Department of Justice, or a 3-judge panel in the DC District Court, to say that these laws weren't going to, quote unquote, retrogress the voting power of Black voters. Through this pre-clearance provision, thousands of laws that could have been passed and would have affected Black and voters of color, mainly Black voters, would have come into play if it had not been for pre-clearance. When Shelby County came down and the court said that the formula was unconstitutional, it opened the floodgates for states in the South in particular to pass these laws that they may have been holding on to for so long to try to diminish the power of Black and brown voters in particular. And so one key thing I want to mention is that the court said the formula was unconstitutional. Pre-clearance itself is not unconstitutional. And so there are certain bills up before Congress, such as the John Lewis Voting Rights Act, which would add pre-clearance back on the table and have a different formula to place certain states and localities under pre-clearance. That would help, ensure that voting rights attorneys like myself don't have to, quote unquote, play whack-a-mole with voting laws throughout the South. We would have some protection from the federal government that would allow us, to focus on advocacy because we knew the federal government had our back. So that's what Shelby County Holder was about.
And now we find ourselves in a situation, and having been someone who was with other activists and advocates who fought for the John Lewis Voting Rights Act, one of the reasons why it didn't pass is because you didn't have the Congress people there to support its passage.
Right.
So that takes us right back to why voting and your protections of voting is important, because you will not be able to get those folks in who will protect your interests.
Correct. It's all very circular, and I call it a dual pronged attack on voting rights in the South. There's an attack at the ballot box itself and who has access to the ballot box. So that comes in the variety, I call it variety of voter ID laws, or early voting laws, and cuts to early voting. In North Carolina, we have same-day registration that they're trying to cut. So they're trying to attack access to the ballot box itself. But then on a secondary level, they're also trying to dilute the voting power of voters. And so there's a conversation about whether or not it is Black and brown voters and other voters of color, or if it's partisan voters, so Democratic or Republican voters. There's a distinction there that the court is trying to parse. The courts are afraid to step into about parsing the difference between race and party in redistricting. And so when you have, again, attacks at the ballot ballot boxes, and they're also trying to dilute the voting power of certain groups of people. You know, it's a dual prong attack on voting rights, and it allows for representatives to be in office that don't necessarily represent the needs of the community.
And that makes sense when I think of Congressional District 1 and Congressional District 6. You know, for instance, I live in Congressional District 6 where those additional Black voters were pushed into. Congressional District 1 is now actually at a boil because of a school board issue. So the people who are on the current Charleston County School Board, a majority of them were supported by a group called Moms for Liberty. And so they had a Black superintendent for 3 months, and these 5 board members who were in the majority had a meeting and didn't inform the other 4 members. And then after a series of meetings, the Black superintendent was put on leave.
Wow.
So that is the current boil that is happening in Charleston County. In addition to that, you know, you've had your other, a number of candidates who, or well, not candidates, actually elected officials, I think 6 or 7 of them, who lost their seats last year after the redistricting, most of them African American.
Yep.
So those are just some of the kind of impacts on Black candidates, Black elected officials, who are going to come in and fight for the kind of things that are important to Black communities.
Right.
And so when Black voters don't have that strength and people are looking to become candidates, they may look at a district and say, well, I'm not wasting my time.
Exactly.
Because
And
the
that,
numbers are against me.
absolutely. And so I think that goes to a distinction. So we talk about equality, and making sure that everybody has equal rights, and specifically in the voting rights context, that we have the equal right to vote. But we also need to talk about equity. And the equity piece of it is making sure that our vote counts as much as everybody else. So make sure the Black vote and the brown vote are, are consistent with the white vote and are equaled out. Because if you are able to dilute the voting power of voters of color, or in this case, Black voters, then there's not equity in their voting power. There's not equity in their voting strength. So regardless of what they do, they still may not be able to select a candidate of choice because of a pre-designed district that they've been put into. And so like that's a shift in the conversation that we need to have nationally. Is equality is great, and I'm all for equality, but we also need to talk about equity and making sure that in the voting rights context, there's no dilution of the vote, and that our votes are, there's equity in the voting power.
Exactly. And what are some things that people need to know about this case if they live in a state outside of South Carolina? Does this case matter to you if you don't live in Congressional District 1, or even if you don't live in the state?
This case does matter because it talks about the entanglement of race and party in redistricting. And so let me explain a little bit about that. And I'll give you some history on that. So historically, there have been lots of laws and cases around racial gerrymandering, but in recent years, I'll say in the last 20 or so odd years, definitely the last 2 redistricting cycles, with 2 to 3 different redistricting cycles, there's been an influx of partisan gerrymandering. And what I mean by partisan gerrymandering is that you have a controlling majority party that is drawing districts that exclude the other party, and it goes both ways. Like partisan gerrymandering is equal opportunity. There are states throughout the country where the Democrats are partisan gerrymandering Republicans, and then vice versa. And so it's a pariah in our society that we need to address. And we would try to address that through the court system. So in a case called Rucho v. Common Cause that went before the United States Supreme Court in 2019, we brought FCSJ and Allison Riggs, who was our former chief counsel and executive director, argued a case that in North Carolina, partisan gerrymandering was unconstitutional under federal law, because it put at a disadvantage a certain group of voters, and diluted their ability to vote. This particular group of voters were Democratic voters, and there were some undertones of racial, undertones in that case as well. But the punchline of that case, the ruling of that case, was that the court said that they were not going to wade into the political thicket of that case, and they said that partisan gerrymandering was non-justiciable at the federal level. And then so it was like, okay, so we said okay, and we went to state court. And just last year, in North Carolina, the state court found that partisan gerrymandering was constitutional under the North Carolina Constitution. That matters because in states like South Carolina and in states like Texas and Florida, Tennessee, I'm not picking on them in particular, but states in the South in particular, if it's not in your state constitution that you can't partisan gerrymander, then states are now using partisan means and partisan reasons to move Black voters around. And that's what happened in South Carolina. Again, the South Carolina legislature said, hey, we want to make this a Republican district because we want to increase the Republican stronghold on the state of South Carolina. And in order to do that, we have to move thousands of voters from Congressional District 1 into Congressional District 6. If the Supreme Court rules in favor of the legislature, so let me back up and say this point, the district court below found for the plaintiffs and found that the South Carolina legislature actually was responsible for racial gerrymandering and that the district needed to be redrawn. The state legislature appealed it, and that's why it's being heard in the United States Supreme Court. If the Supreme Court agrees with the legislature, that means in other states,
we're going to stop our share now.
The state legislatures can draw districts based upon for partisan reasons, but with the movement of Black and brown voters in different districts to achieve that partisan aim. That goes against.
I'm not sure how.
You might have to go back and share again, and then just pause that or
for 30, 40 years.
X out of it, because
but if the court changes its mind and says, hey,
and pause it.
This wasn't partisan, this wasn't racial gerrymandering. They did it for partisan reasons, and we're not going to touch it. That's why I have a long.
Nope. Wait, go back and do that again. I think
go back and do it again. I'm sorry.
Go back.
And I'm also. I see a pause.
No, pause.
When you talk about
pause the video. There you go.
There's a tendency. Okay. And now stop sharing. I'm sorry about that. These are a little interesting, but we wanted to make sure we got both of our interviews in and to give Charles a chance to weigh in on what he has heard so far.
I want to talk to you not as a legal person, but as a community advocate. So I'm going to cut through some of the legalese. What happened in District 1 and District 6 is they basically split Charleston down the middle, put all the Black voters in Clyburn's district and all the white voters in Mason's district. So they use race to achieve political ends. And that's what the case is about. He also mentioned the Constitution, state constitutions. In prepping for this and some other things, I went back and looked at a book that I have, which is called The Segregation Fight of 1895 in the state of South Carolina. It was written by a professor, Damon Fordham, at the Citadel. And one of the things that he brings out is that Constitution, what Constitutional Convention, was created to overturn everything that was achieved in Reconstruction and also in the South Carolina Constitution of 1868. Which was done during Reconstruction, okay? And the chief aim of that, and that effort was led by then Senator Ben Tillman, and by the way, his middle name, as most of us in South Carolina know, his nickname was Pitchfork. That was for a reason, okay? And it was led by Tillman because the main purpose of that 1895 Constitutional Convention was the disenfranchisement of Black voters. the politicians and the white politicians and the white supremacy groups in the state of South Carolina felt blacks had accumulated too much power. And regardless of what the 14th and the 15th Amendment said, and also probably what the 13th Amendment said, they were going to write a constitution that was going to negate the 14th and 15th Amendments. And guess what? They did it, okay? They did it. And so this fight that we're having in South Carolina today in Alexander, versus the state of South Carolina is a centuries old, decades old battle. The handbook was written in 1895 to disenfranchise Black voters. And the only thing I can say is to my state of South Carolina, which I love, enough. Okay? And that's what this case is about.
Exactly. Well, I'm going to try to pull up the second video so we can listen to some of that, and then we're going to go ahead and do our summary. So let me bring up our second video.
Yeah, and I was going to say, Elizabeth, I think we can do your question after the second video, so that way we have all of our stuff in.
Okay. Now I had to open this video. And I think I've done that. Okay, there you go. Okay, and we are thankful today to have.
I forgot I was muted. Hold on. You're going to have to go out and then screen share that video.
Okay.
I know it's tough. I've tried to share my screen before with Paula and our other coworker, and I'll pull stuff up and she's like, I can't see that. I'm like, oh Lord, that's another screen.
Okay, and I'd
There you
like
go.
Can you see it? A little bit about your role with the Legal Defense Fund and your role in this case in Alexander versus South Carolina NAACP.
Thanks for having me. I am a litigator with the Legal Defense Fund. Part of my portfolio of cases includes voting rights. And I have been on this case since its conception, when we filed a complaint against the General Assembly for passing congressional maps that we alleged were both a racial gerrymander and a product of intentional discrimination to dilute the political power of Black voters. And so we have litigated this through trial, and now we're before the U.S. Supreme Court seeking an affirmance of the unanimous three-judge court's ruling at the lower court, declaring that Congressional District 1 was unconstitutional, and we're really working to uplift this victory for Black voters and to preserve it so that Black voters in Congressional District 1 in South Carolina can vote in fair maps in future elections.
Now, tell me a little bit about the timeline for the case. You talked about the start of it. So what is the calendar timeline?
So the case, we filed a complaint in spring of 2022, and we went to trial in October of 2022. We received a ruling from the court in January of 2023 and have been briefing appeals before the U.S. Supreme Court since then, and we're going to oral argument on October 11th, 2023.
So what is the impact in a win? What does a win look like? And what does a lose look like? I don't know if you want to put it in win-lose language, but what are those two outcomes look like for South Carolina Black voters?
A win looks like having voters in Congressional District 1 being able to influence their elections with their preferred candidates, which translates into increased federal resources for healthcare, for broadband internet, for medical care such as insulin caps, and is having elected officials which are responsive to their needs and which can really serve their communities in ways that currently are not occurring because the political leadership understands that when you divide Black communities based on race and when you dilute their political power, do not have to be responsive to their needs and to their petitions for resources and representation.
Well, as a matter of fact, there's a current issue right now with the Charleston County School District. And there are 9 board members on the school district. 5 of them are in one group
She's one of the judges. The judges were
that
the
is alleged to be
mosquito
connected with
bite.
Moms for Liberty, and the other 4 are not. And so these 5 have removed a superintendent and have done so in a way that didn't include the other 4 board members. So we're kind of seeing in real time what happens when you don't have that representation. So that will include CB1, but it includes many other races as well, many other elections as well, that people don't have voting straight. Isn't that right?
So our litigation is focused on the congressional map, in Congressional District 1, though there are efforts that are being led across the state to really create more equity as well in local and state redistricting. Black people need political power at every level of their community. And we are right now in this current case, focused on the congressional map, but we also are supporting efforts to help create more fair representation at the local and the state level as well.
Okay, that makes sense. I appreciate that clarification. And now tell us a little bit about LDF for people who don't know what that is. Who are you all? How long have you been here? And what are the main fights that you're involved in?
We are the NAACP Legal Defense Fund. We were founded in 1940 by Thurgood Marshall, who many of your viewers know was the first Black Supreme Court Justice. The Legal Defense Fund litigated Brown v. Board of Education, ending educational apartheid in our country. And we've been committed to ensuring that Black people have dignity and belonging in this country ever since our inception. And we have various focus areas, including political participation. And so this case is really part of our core. We also litigated the Milligan case last year, with the Supreme Court upheld the Voting Rights Act and Section 2, and the requirement to draw a second congressional district for Black voters in Alabama. And so we've really been in this current season fighting for Black voters across the country. And in this current moment, we're really uplifting Black voters in South Carolina to help ensure they receive their full constitutional protection in the election process.
So tell me what people who do not live in South Carolina, why should they follow this case? Why should they pay attention to this case, and what impacts could it have outside the state of South Carolina if there is a win?
This case is important for our country as a whole. This is about our congressional map, and we have a 3-judge court has already found that the congressional map that was used in the last election was unconstitutional. And having elected officials in our national legislative body being elected under maps that do not comply with the U.S. Constitution undermines our entire democratic process. As a country, we all want to have a Congress that is representative of the people, that is fair in its electoral process. And South Carolina is the current state that is being sort of highlighted, but this is about our democracy, and this is about Black voters having a political voice in South Carolina, but also in every state. This is a case about how we cannot allow elected officials to use Black voters as political pawns to gain power. This is a case about how we need to ensure that the U.S. Constitution applies to all of our citizens and not just certain demographics.
Exactly. when October 11th comes, there'll be a number of supporters and maybe opposers there in Washington, D.C. To convey their message. Now, how is this a part of upholding democracy, having all those voices out there?
Yeah, having dialogues about different opinions regarding what is true and what is not true, I think is very important. And we've earlier had a dialogue in this case where 3 judges determined that it was true that Black voters were harmed by congressional maps in South Carolina, that it was true that these maps were the product of intentional vote dilution tactics. And now as we approach the U.S. Supreme Court, we're confident that the court will also hold that it is true that Black voters have been harmed in South Carolina and that there needs to be a remediation of that harm so that Black voters can make their ballots and their preferences known under fair electoral maps.
Okay, well, with that, we're going to stop there. We do have a question that we want to answer, and then we're going to wrap up with any other remarks that Charles and any of the other viewers may have. So I have a question that says, since the majority of African-American voters vote the Democratic ticket, it seems that race and politics are one and the same in racial gerrymandering decisions. Is there a way to legally distinguish one from the other?
I'll take a shot at that.
Okay.
And thank you, Elizabeth. I think that's a good question because I asked myself that same question. The way the Voting Rights Act is set up and when it was approved in 1965, there was a political effort to the Voting Rights Act, and there was the racial effort to not disenfranchise the rights of Blacks, and it was specifically for Black voters. So over time, however, when we've had redistricting since 1965, the political and the racial have moved closer together. And what we've done in South Carolina, I believe, like I'm not a lawyer, I believe that what we've done is to use race to justify and legitimize the political aspect of it and the partisan. So the Republican legislature is saying, oh no, this is not racial, it is partisan. So they moved them so close together that they're kind of muddy. And I think what the case is about is to say, let's pull that apart. Mm-hmm. The partisan wouldn't happen without the racial gerrymander. Right.
And I'll also add in there, even though I've been talking plenty in the 2 videos, so I'm gonna keep my comments short. We noticed that when you take political parties to court, there's the understanding that, okay, this is an organization, they make their own internal rules and decisions, and we're keeping out of that for the most part because they're like a private club. So wrapping things up in the partisan frame does allow for things not to be addressed. So we do need to find the distinction, pull that apart, and that's what the attorneys will be doing to make sure that there aren't harms to Black groups and to other racial groups.
Catherine, as we begin to wrap up, I want to make 2 more points, and I'm jumping in because I know we're getting ready to wrap up. When I was preparing for this, I went to just do a little reading, and I found something that I thought was very interesting. The first Black person to be a representative in the U.S. House of Representatives was a gentleman by the name of Joseph Rainey. Mm-hmm. He represented District 1 in South Carolina. Wow. So I just think it's kind of ironic that we're having this fight when the first Black person in the U.S. House of Representatives came from that district when it encompassed Charleston. The other thing I want to mention is kind of amplifying what Antonio said, why this is important. Mm-hmm. The other thing that we don't talk a lot about is that the redistricting that we're talking about is a result of the census, which happens every 10 years. Mm-hmm. It is part of the Constitution, the apportionment clause. So as we look at South Carolina, okay, going forward, South Carolina potentially will pick up another congressional seat in 2030 or the cycle after. And why is that? When you look at the demographics and the data from 2020, a lot of the states that were in the cold states, meaning where it snows a lot, up around the upper Great Lakes, they lost population. And as a result, they lost a seat in Congress. Okay? Those went to places like Texas, North Carolina, and places like that. Well, the population trend with baby boomers retiring, and all baby boomers will be retired by 2030. Okay, will be of retirement age. Let me rephrase that. We'll all be of retirement age by 2030. They are leaving cold states and coming to warm states. When you look at the demographics of South Carolina, the bulk of those people went to the coastal communities. Okay, that's where a lot of those people, when they retired to South Carolina, went to the coastal communities. So as the Republicans and those in our legislature also look at those trends, they want to create safe districts. Nancy Mace's district is just under 70% white. Okay, so people are moving to there because those are the resort communities. So we have to have this litigation now. We have to have this fight now, because if we don't correct this, imagine what that's going to look like if we get another congressional seat after 2030. So that's another reason why this is important.
Yes. So thank you very much for that. We are thinking about voices in a dialogue from so many different perspectives. You know, we're looking at it in terms of people moving to different states. We're looking at the racial makeup of those states. We're looking at people in communities and districts being able to have a strong enough voice to make their representation meaningful. So this case, and the historical part that you brought up, the fact that we're one of the places where we have the International African American Museum, and there's so much connection to our history, means that this is a place where people will really be able to look at this case to have a good understanding of where we go from here. So I do also want to promote, Charles and I are in a group that are working on a rally that will be in front of the State House. That will be in front of the U.S. Supreme Court on October 11th. And once again, that's another opportunity for South Carolina voices and voices from other parts of the country to be heard in the public sphere space as this case is being decided. So if anyone is interested in that, I will actually try to put my email. I think I put my email in chat, right? Yes, I'm gonna, okay. Yeah, I'm gonna make an effort to do that so that people can reach out to me. And
yeah, you can do that.
Okay, I'm trying to see where.
You can.
Catherine, while you do that, can I have one last 30-second comment?
Sure, yes.
South Carolina is the only state in the union that does not have guidelines for its legislature when it comes to redistricting. Every 10-year cycle, we hand it off to the Judiciary Committee to come up with the rules for engagement around redistricting. We also don't have a redistricting commission, nonpartisan or partisan for that matter. So South Carolina, and I guess I'm not being too inflammatory, is the wild, wild state. You know, wild, wild west when it comes to redistricting. We make up our own rules, and guess what? There's no oversight. So that's another reason why we have to deal with these kind of issues in court cases now, and we're going to be working on trying to change that between now and 2030.
Yes, yes. So please join us. My email is in the chat. It's TNOVSA, TNOVSA, Global Commons @gmail.com. And so we will send you information about the rally, but we will also send you information about some of the other actions that SC Counts 2030, connect you with them, connect you with Solve and other groups that are working to ensure that everyone's voice in South Carolina is heard so that we can have a true dialogue. So I want to thank Mitchell Brown. I want to thank Antonio Ingram. I want to thank Charles for being here in person. I want to thank all of our guests. I see Elizabeth there. Thanks so much for joining us. Want to thank the Atlantic Institute for making this opportunity available for not only me as an independent presenter, but several others across the country are bringing their ideas and presenting them in this forum. So we're so thankful that they decided to do this new initiative. This should be on the Atlantic Institute page tomorrow. So look for that, and please do share that with other folks in your community.
And can you tell us about the event we're going to have Friday too?
Okay, and so this is part one of our dialogue about the Alexander versus SCNAACP. On Friday at 7 o'clock, we're going to ask you to come back for part two of that dialogue, where we will be looking at the amicus briefs. Those are called Friends of the Court. And we have had friends from both sides of the argument present these position papers, which are available to the public to read, but they're pretty dense reading. So we're going to break that down for you, make sure you understand the different positions and who is presenting what, and we'll have some guests on the show to join us in that conversation. So October 6th, Friday at 7 o'clock, we hope you'll come back and join us for that conversation. And October 11th, I hope some of you will be coming with us to DC to be there and stand with us in front of the U.S. Supreme Court.
Thank you very much, Catherine, and thank you very much, Charles. I thank you both for being here, and thank you for those that got on here. If this interests you, I hope to see you back again on Friday, and I hope that you let others know as well to go ahead and get on and join in this conversation so you can listen and learn. And with that, we will go ahead and wrap up. Feel free to unmute yourself, and you can feel free to thank our speakers. We had here Catherine and Charles. And you all have a great rest of your Sunday evening.
Thanks, everyone. Thanks for coming.